just like we discussed yesterday, since we're trying to get this witness out of the way, we still have to introduce our exhibits.
I got that. I got that.
I mean, they rested before we did,
I got that.
You guys rested yesterday,
subject to the admission.
Correct. and we're gonna do the same thing. So
Yeah, right.
All rise.
Everyone can have a seat. Election day today, so go vote if you haven't already. Any further witnesses on behalf of the defense?
No, with the conclusion of Mr. Scanlon's testimony, that concludes our case, Your Honor. We would rest subject to the admission of our exhibits at the appropriate time.
Any witnesses on behalf of the state?
We do, Your Honor. We'll call Professor Seth Stout.
We will be doing this via Zoom.
Pardon me?
We'll be doing this via Zoom.
Yes, Your Honor. Am I blocking anything?
Mr. Stoughton, can you see and hear us?
Yes, Your Honor.
Can you raise your right hand? Solemnly swear or affirm under penalty of perjury your testimony in this case will be the truth, the whole truth, nothing but the truth?
I do.
You may inquire.
Thank you, Your Honor. Would you please start by telling us your name and spelling your name?
My name is Seth Stoughton, Sethstoughthoun.
And how are you employed? What do you do?
I am a law professor at the University of South Carolina School of Law, where I'm also the faculty director of the Excellence in Policing and Public Safety program and a professor by courtesy in criminology and criminal justice.
And what particular professorships do you have at the law school?
I have it's called an endowed chair. I am the Mitchell Willoughby Professor of Advocacy and Public Justice. I teach at the law school. That's my primary job. So I'm kind of just a law professor there. The faculty director position is a program that exists within the law school, the Excellence in Policing and Public Safety program. The courtesy professorship is because of my work with my colleagues in criminology and criminal justice, but I do not have any regular teaching or administrative responsibilities in that department.
You may. Everyone can have a seat. Get your steps in today. Let's take a. Dr. Stoughton, can you hear us now?
Yes, Your Honor.
You may continue.
Thank you. And Mr. Town, you're testifying, is there a reason you couldn't come to court today? Scheduling?
Yes, my schedule this week is on the other side of insane, I'm afraid.
Okay, so you're testifying from your office?
From my home office, yes.
Okay, well, thank you for your time. Let's get back to, I believe you were discussing about your professorships at the school. Can you tell us a little bit about the work that you do at the Excellence in Policing program at the law school?
Sure. That is a program that was funded by the South Carolina legislature about 4 years ago. We've been fully operational since January of 23. The legislature funded that so that there could be professional development training, especially professional development opportunities for police executives in South Carolina and beyond. So we do a couple of different things, but one of the big ones is we run a executive credential in police leadership. We're on our 4th cohort of South Carolina police executives right now, where they're with us for a total of 8 months. In the 8 months, they meet with us for usually 4 days a week for once a month for that 8-month program. We also do a series of one-off trainings that aren't part of that program where I or my staff travel around South Carolina or beyond to provide primarily supervisor and police executive level training. We also have a research and technical assistance arm. So I have a full-time director of research who works with police agencies doing right now focused deterrence project and hotspot policing research, sort of a crime prevention focus with that.
Okay, I'm sorry.
Go ahead.
And that's just
No,
not
no.
South Carolina, right? That's just not
The
South Carolina.
Yeah, the legislative funding funds our activities in South Carolina. We are active more broadly than South Carolina. The core of our activities right now are South Carolina, but we've done one-off trainings, and then a number of my instructors and I, my staff and I, participate in events well beyond South Carolina, representing EPS in conferences or trainings or professional development more broadly.
Okay, and what is your role with the Excellence program?
I am the faculty director there. So as faculty director, I oversee a staff that includes an executive director, a director of training, a lead instructor, a director of research, a COO type position, a part-time strategic advisor. We split time with an administrative assistant. So I oversee this handful, 5 or 6 employees. As faculty director, I do a lot of the development and delivery of certain of our training modules. So when we started our 4th cohort last month, I'm one of the primary instructors in our Principles of Leadership and Management course. I'm one of the primary instructors in our course next week, which is our Civil Rights for Public Safety Leaders course. I also help set the sort of strategic decisions and priorities. So I consult with the staff, but then decide how we're going to continue to expand operations, the sort of scaling and pace as we continue to develop and grow.
Okay, and along those lines, are you also a professor at the law school?
I am, believe it or not, that's my primary job. The faculty director thing is in addition to that.
And what law school is that?
The University of South Carolina Joseph F. Rice School of Law.
And can you tell us what type of courses you teach there at the law school?
Sure. I teach a criminal law course, which is a required course in the first semester of the first year for law students. I teach a criminal procedure course, which is an upper level, meaning second or third year students course that focuses primarily on the Fourth with a little bit of Fifth and Sixth Amendment. I teach a police law and policy course, and I teach a regulation of vice seminar.
And how long have you been a professor there?
I just finished my 11th year here.
And where did you attend law school?
I went to law school at the University of Virginia.
Now, do you do scholarly research as your role as a professor at the law school?
I do, yes.
Can you explain to us what type of research or research that you do there as a professor?
Sure. So I am an academic who studies policing. I do academic studies of policing. I study multiple aspects of policing. A whole bunch of different aspects of policing, from sometimes legal rules that regulate policing. I have articles on the Fourth Amendment, administrative rules like policy, less formalized rules that affect police behavior, things like culture, the way that police technologies inform the practice of policing. Basically, the articles and book chapters and so far one book that I've done or co-authored all focus on some aspect of policing and police practices.
Okay, Professor, I'd like for you to explain to the jury about your experience and education that led you to be in the position that you're today at the law school.
Sure. You mean my professional experience before going to law school?
Yes, give us your professional experience that you have.
Okay. I started.
Mr. Schroyer, do not speak over, especially on a Zoom.
I'm sorry. Just beginning at the beginning of your career forward.
Certainly. I started my career as a police officer with the Tallahassee Police Department in Tallahassee, Florida. I was a city cop there, assigned to the patrol division for a little more than 4.5 years full-time. I left that position and went to a job as an investigator with Florida Department of Education's Office of Inspector General. While I was there for the first 6 months or so, I stayed on as a reservist with the police department, but a reservist is a part-time volunteer position. Sorry, I should specify, it's a part-time position. It's not voluntary. You get paid hourly, but it's a part-time position. I was with the Florida Department of Education's Inspector General's office for between 2.5 and 3 years, not quite 3 full years before going to law school. Then I went to law school. When I finished law school, I clerked. I worked for a federal judge for a year. And then had an opportunity to go into an academic fellowship, which is where I did. So that's where I started studying policing. That was August of 2012, I believe, maybe July of 2012.
So you're actually a police officer at Tallahassee, is that correct?
Yes.
And what years were you there at the Tallahassee Police Department?
I was there full-time from beginning of 2001, February or March of 2001 until October of 2005, I think, full-time. And then I stayed on as a reservist until June or July of 2006.
Okay. And to be a police officer with Tallahassee Police Department, did you go through training? And as a reservist as well, did you go through training?
Yes.
And can you explain what type of training that you went through there?
Sure. So the first training was our police academy. Florida has a number of different academies. I went to one of the regional academies, which means it's not an agency-specific academy. It's an academy that trains folks who are employed by or who will be employed by a whole range of different police agencies. That was until May or June of 2001. The police department has additional classroom training and then field training. So I went through the additional, I don't know, 4 or 5 weeks of classroom training, and then it was 3.5 months or so of field training. So I was in training at the police department from whenever I started until November or so of 2001.
And what was your position there at the Tallahassee Police Department?
I was a patrol officer. I was a uniformed beat cop assigned to the uniform patrol district. I worked a couple of different shifts in a bunch of different zones in my time there, but my primary assignment was entirely as a patrol officer. I also had some additional assignments beyond just being a patrol officer. I taught report writing for the agency and the use of new technologies. I was pulled onto a focus group to help develop some policy for technologies at the agency. I spent about 2 years on our special response team. I taught self-defense classes and like kids self-defense classes for a couple of years there. But all of that was around my primary role as a patrol officer.
Okay. And you mentioned, as far as a patrol officer, tell us what your duties were as a patrol officer.
Yeah, so that's the uniformed officer that responds to calls for service or engages in what's referred to as proactive policing, making traffic stops or getting out and speaking to people or conducting business checks. That was it. That was being on patrol, driving a beat.
And you mentioned something, you were also part of what you called a special response team. Can you explain to us what that was all about?
Yeah, so my agency had 2 different tactical teams. We had what we called TAC, or Tactical Apprehension and Control. That was our SWAT team, essentially. The other tactical team was the one I was on, which was our Special Response Team. That was our tactical team that had advanced training and equipment in crowd control and riot response situations.
And so were you familiar with deadly force training while you were there? Use of force?
Yes.
Okay.
Yes.
Now, you indicated that I think your career took you after that to the Florida Office of Inspector General?
Yeah, in the Department of Education, the Office of Inspector General there, yes.
Right. And what did you do for the Office of Inspector General?
I was an investigator within that office, which is divided between an investigative section and an audit section. I had nothing to do with the audit section. As an investigator, I conducted criminal or administrative investigations related to matters affecting the Department of Education. So I wasn't investigating teachers. The teachers are employed by individual school districts. But if we had Department of Education employees who engaged in misconduct or were alleged to have engaged in misconduct, then we were, that is the investigator section, we're sort of like an agency internal affairs. And with any of our contracts or tuition voucher programs, et cetera, when there were allegations of criminality, waste, fraud, or abuse, we would come in and handle those investigations. So we were sort of a combination of internal affairs, administrative investigations, and criminal investigations.
Now, at some point then, you ended up going to law school and becoming an attorney, is that right?
Yes.
Okay, and was that during this period of time when you were also an officer and worked for Florida, or tell us where this fits in?
I left Apologies. I left the Florida Department of Education in June or July of 2006. No, 2008, June or July of 2008, which is when I went to law school. So that part did not overlap.
Now, I want to get back to your profession here. Have you authored any publications
Yes,
dealing with use of force policing?
yes.
Can you tell us about those?
Sure. So I have a number of academic articles. I have some book chapters. I have a co-authored book that all focus on tactics, use of force, and issues related to the use of force.
Okay. And how many publications do you think you've done on these?
Oh boy. If just academic publications, I mean, definitely the book, at least 2 or 3 of the book chapters have been on these topics. I don't know, maybe 3 or 4 more of the articles have been on these topics. I haven't broken it out in my head quite that way before.
And are you a member of any professional organizations related to your profession?
I am, yes.
And can you tell us about those?
Sure. I am a member of the International Association of Chiefs of Police in the Legal Officers section. I am a member of the American Society for Evidence-Based Policing. I am a member of the American Law Institute, where I previously served as an advisor to the Principles of the Law Policing Project and am now an advisor to the Constitutional Torts Project. I am a fellow of the American Bar Association. I'm a member of the Virginia Bar, an associate, meaning a non-practicing member of the Virginia Bar. I am a member of the, I'm an associate member of, I think it's the International Prosecutors Alliance. I might have a couple of other professional associations that that slipped my mind right now.
And do you do any consulting, research with other police agencies?
I do. I've been retained by a city, for example, to conduct an investigation and provide recommendations specifically into a use of force. If you mean consulting and training, yeah, I do. That's part of why I can't be there this week. I was in Washington, D.C. yesterday, teaching a section in the Washington Metro's Police Leadership Academy on use of force review and evaluation. Tomorrow, I do the same thing for a Police Leadership Academy out of the Charleston Police Department here in South Carolina. So there's quite a bit of police-specific training. Earlier this year, maybe it was late last year, I was up in Nashville doing it for a Tri-Cities leadership summit that they host. So yeah, there's a lot of that.
And do you also engage in consulting as an expert witness on police practices?
I do, yes.
And what type of cases do you consult with as an expert on? A mix as far as civil and criminal?
Yes, it's a mix of civil and criminal cases. I would say, well, it's primarily civil cases, but also criminal cases.
Okay. Do you charge a fee? Well, let me back up here. You charge a fee for your time. when you appear as an expert witness in policing practices. Is that correct?
I do. For all time that I spend on a case, reviewing materials or preparing reports or actually appearing, yes.
And would you tell us what your fee, hourly rate is, your fee?
In this case or more generally?
Well, in this case.
So I was retained in this case at $3.85 an hour.
Okay. And is that the government rate?
I forget what that was at the time, whether that was a government-specific rate or not. My rates have since increased, but that doesn't affect this case.
Now, you were contacted by the state regarding this case and to retain you for analyzing the facts and circumstances surrounding the conduct of the defendant, use of force and tactics. Is that right?
Yes.
Can you, did you prepare reports that would indicate what your findings and opinions were? In this matter?
Yes, I did.
Okay. And do you have those reports with you?
I can, yes.
No, I didn't know if you had them with you or not, or whether or not you needed them. Okay.
Yeah, yes, I do.
All right. And it's okay for you to refer to them if you need to refer to them. Is that okay?
Yes, thank you.
Okay. So what is your process for analyzing a case such as this?
Sure. When I'm initially contacted about a case, the first step is to identify with the attorney what the relevant issues or what types of issues we're talking about. Sometimes in that preliminary conversation, it turns out that it's outside of the scope of my expertise, or maybe it's within the scope of my expertise, but I may be able to recommend a stronger expert, a better expert in that area. Once I identify with the attorney that whatever the relevant issues in the case are within my wheelhouse, then we formalize the retention and I get the materials, or at least an initial set of materials. I review the materials and I can dive into more detail if you want, but essentially I review all of the materials to make sure that I have a thorough understanding of the facts. Once I have a thorough understanding of the facts, then I identify what the standards are that apply to those facts. That is, what the generally accepted principles or practices that applied at the time of that incident actually were. Then I do the work of comparing the facts, the officer's decisions or actions, to that standard. I develop what is at least a preliminary opinion, depending on the materials that I have received thus far. I usually have a follow-up conversation with the attorney and tell them this is what I've reviewed and these are the applicable standards and here's my opinion at this point, given the materials that I have. And often at that point, the attorney makes a decision about whether I should proceed to formalize my opinion in a report, or in the event that my opinion is not helpful for them, perhaps not do that and we maybe go our separate ways.
Okay, so did we provide you with a bunch of material surrounding this matter?
Yes.
Okay. And can you tell us, I mean, some was probably maybe relevant to what you needed to make your conclusions, opinions, maybe other material not. Can you tell us what the relevant portions of all the materials you got that you felt was relevant to make conclusions and opinions in this matter on the use of force and tactics?
Sure. So I think it's fair to say that any material that I review, anything that I'm provided, has at least the potential to be relevant. I won't know until I review it, and even if it doesn't end up affecting the analysis, it's not that it is irrelevant, right? So I just want to make sure I'm not I'm not cherry picking and saying that certain things that I'm going to mention, like, do or do not matter. It all matters because that's the entire body of material that I have that informs my understanding of the case. So in this case, I have an incident report from Columbus Division of Police, along with some informational summaries. I have similar reporting from the Federal Bureau of Investigation. There's some information out of the Franklin County Sheriff's Office. There were a number of audio recordings, 911 audio and radio traffic and the like, recorded interviews, photographs. There were some video recordings, security or road video. There was at least one body-worn camera, along with some miscellaneous documents in the file. There was a search warrant application, for example, and statements, a statement by the defendant. And then after the initial tranche, more recently, I was also given an additional expert report by Dr. Bauer.
Did you also actually go to the scene?
I did, yes.
And what was the purpose for going to the scene?
Primarily so that I could ensure that I understood the sort of geography and distances involved beyond just looking at pictures. Looking at pictures is not a bad way to get a sense of the scene, but it is not as effective as actually visiting the scene and getting a sense of how that scene layout looks.
And Professor, I'm going to, I'm not sure how we do this since you're by Zoom, but it's States Exhibit 28.
That's not going to be seen. You have to share the screen with your computer.
And you've seen that photograph before, haven't you?
Yes, I believe so.
Okay, and is that the photograph of where 3996 Estates Place, correct?
Yes.
And so that was part of the materials that you looked at as well?
Yes.
And as well as when you went to the scene, it just kind of shows out in the yard area with some trees and stuff. Does that refresh your recollection as to what the scene looked like?
It does.
Now, before we get moving forward, can you tell us what's the next thing that you do after receiving all the materials, you're going through it? What's the next thing in your process of doing your analysis?
So that first part of reviewing the materials is just ensuring that I have a thorough understanding of the facts of the case. As part of that, I look for discrepancies in the evidence. As an expert, it's not my role to resolve those discrepancies, to make credibility determinations, for example, or to say that this set of facts is more likely or less likely than another set of facts. So I identify those discrepancies because I may end up bifurcating my opinion. That is saying something like, when there is a discrepancy in the facts, if you believe this set of facts, if we accepted that as true for purposes of my analysis, then I have a particular opinion. And if we accept a different version of facts, if we say that this is true for purposes of analysis, then I may end up having a different opinion. I would say all of that is kind of within the scope of ensuring that I understand the facts of the case.
And after doing this, relying on your training your practical and academic experience, were you able to reach conclusions with respect to this incident?
Yes, I was.
And were those opinions and conclusions you reached within the professional and generally accepted standards in your field of policing?
Yes, they were.
Now, can you, now you probably covered some of this, but so what is the methodology that you use? You gather the information, and how do you come to those conclusions and opinions in the case?
I'm sorry, the audio fuzzed out there a little bit. How do I what?
Yeah, tell us your methodology then, as far as how do you go about reaching your conclusions and opinions?
So after I identify what the relevant facts are, and again, flagging any of those discrepancies that I mentioned earlier, the next part of the job is identifying what standards, what generally accepted principles or practices in policing existed and applied at the time of the incident. I want to clarify that last point. I specify at the time of the incident because principles in policing and certainly police practices change over time. So my role as an expert is to identify what the generally accepted practices are, right? What the prevailing professional norms were at the time of the incident in question. I suppose the next step is, once I've identified what those generally accepted practices are, and I can get into the methods of how we do that, it's then to essentially compare and contrast, right? I take the officer's decisions and actions, and I compare them to the generally accepted principles and practices.
Okay. And are you looking?
Is that what you were asking?
Yeah. What type of thing? Are you looking at tactics?
Depending on the case, yes, it certainly can be. So when I talk about, sorry, go ahead.
No, in this case, what is it that you were reviewing it?
Yeah, so in this case, there is a tactical component and then there is a use of force component. So the two areas that I'm looking at are tactics and use of force.
Okay. And would you tell us a little bit about, first of all, I guess, tactics? What are tactics and why are they important to look at?
Sure. Tactics are the decisions, the actions, the techniques that officers use to manage the inherent dangers of any given situation. It's how officers balance the need to conduct the police mission, whatever that is in the particular context, against the need to preserve the safety of community members, of officers, and of the subjects or suspects with whom officers are interacting in what's called the hierarchy of human life. Tactics are important because, in a very sort of concise way, when we use good tactics, we increase the likelihood of a good outcome and we decrease the likelihood of a bad outcome. That's ultimately what tactics are designed to do. It's not that officers can automatically render any given situation perfectly safe. But if we're sort of starting with all other things being equal, there are some tactical approaches that will be safer in one situation than another tactical approach might be. So tactics are the tools that officers use to increase the likelihood of a good outcome and decrease, to the extent possible, the likelihood of a bad outcome.
And how is that relevant to generally accepted police practices? How do these two fit together?
Sure. So tactics both grow out of generally accepted principles in policing and also are generally accepted principles and practices in policing, right? If we start with the sort of underlying generally accepted principle in policing that sanctity of human life and preservation of human life is the highest priority in policing. That's pretty well established and certainly generally accepted. From there, tactics are one tool that officers use to do that, to help preserve not only their own lives, but also the lives of community members and the individuals with whom they're interacting in ways that facilitate the safer, if not perfectly safe, the safer performance of police duties. So growing out of that idea of sanctity of human life and being able to facilitate the safer conduct of police operations, policing in the last 100 or so years has developed a pretty wide spread of different tactics, tactical principles and concepts, as well as very specific, sometimes tactical practices that help officers decide and approach a situation in the way that is most likely to get a good outcome or to decrease, again, to the extent possible, a bad outcome. So for a very, very simple example, when an officer makes a traffic stop and the other vehicle pulls over on the side of a busy road, there is at least some risk that an officer who gets out of their car may be struck by a passing vehicle. We use tactics to determine where the officer may position their own vehicle to help reduce that risk. Or maybe we use tactics of the officer walking up on the passenger side of the stopped vehicle instead of the driver's side to further reduce that risk. Or the officer might, for example, get on the public address system and tell the vehicle to pull forward to an area that's a little safer to conduct that traffic stop. That's a very prosaic example. It's a very sort of everyday thing, but that's kind of exactly the point. Tactics are so deeply embedded into policing that there are all kinds of tactical decisions and tactical actions that don't look special because they're really not special, right? Tactics are just baked into the way that we expect officers to go about doing their job.
And you mentioned generally accepted police practices. Can you explain to the ladies and gentlemen of the jury what that standard is? What is that?
Sure. When we're talking about well, let's distinguish between two things, right? First, I mentioned principles and practices, and they're a little bit different. When we talk about generally accepted principles, we're talking about concepts or maybe somewhat abstract statements that are nevertheless widely known and relied upon and acknowledged within the field of policing. The one I mentioned earlier, sanctity of human life, is the highest priority in policing. That's an example. It's not a practice in the sense that it's telling officers exactly how to do something, but it's a principle that informs and should inform what officers actually do.
Yeah.
Practices are a little bit more, I'm sorry, go ahead.
That's where I was going to next. Go ahead.
Practices are a little bit more specific. They are more like protocols or techniques or procedures. So I mentioned, for example, in the traffic stop example, an officer might park their car in this way or that way. They might approach on one side or the other. Those are not principles because they're not abstract. They're very concrete in the sense of guiding what officers are actually doing in a very specific way. So that's what we mean by a practice. Now, both principles and practices are really only relevant for my purposes as an expert when they are generally accepted in policing. And what I mean by generally accepted is these are the prevailing norms. These are conventional, these are customary. These are the things that I would expect if I had gone to any officer at any agency, pretty much anywhere in the country. They would say, yeah, that's more or less how we do things. That's right. Because that represents not just a specific agency's practice, but it represents a consensus, a general accepted principle or practice across the profession of policing.
Now, we'd heard something about, well, let me back up, I'm sorry. So how do you evaluate the officer's conduct is consistent with these general accepted police practices? Because there's different options, right? Available to the officer.
Yes, absolutely, right. And one of the most important points here is just because there is an alternative option available to the officer, that does not mean that what the officer chose to do was not professional. When we're talking about generally accepted principles and practices, what we mean here are what one source described as institutionalized behaviors or norms that we expect an officer to engage in. But that's not a one size fits every situation, and it's not there is only one option for any given situation. Often, what generally accepted principles and practices tell us is that there is sort of a spectrum, right? And there's a line on that spectrum where what an officer does on one side of the line might be perfectly in keeping with generally accepted practices. It's professionally reasonable, it's appropriate. And there might be multiple things on that line. The officer might be over here, or might be over here, or might be somewhere else. But as long as they're on that side of the line, they're acting in a way that is consistent with generally accepted practices. If we go back to that traffic stop, for example, the officer might choose to walk up on the driver's side or might choose to walk up on the passenger side. Both of those, either one, might be perfectly consistent with generally accepted practices. But at some point on that spectrum, there's a point at which the options are no longer reasonable, where the options are not consistent with generally accepted practices, right? So if we think about that traffic stop scenario, the officer might approach on the driver's side or the passenger side, but it would be inconsistent with generally accepted practices for the officer to climb up on the trunk of the car and crawl up over the top and put their head down right in front of the windshield, right? That would be really, really weird. So the best way to think of most situations is not what is the right answer, because there often is no single right answer. It's what are the set of professionally reasonable options available to the officer in this situation, and then what options are not included in that set of professionally reasonable options. What set of options might be professionally unacceptable or professionally incompetent.
So they're basically, it's the lowest level of when you're doing generally accepted policing practices. You're starting here, and that's where everybody should be. Is that what you're saying? Every law enforcement agency.
Yeah, that's exactly right. We're not talking about best practices, right? We're not talking about the things that the best funded, largest, best trained, best supervised agencies have available. We're not talking about reliance on advanced principles or practices or technologies. We're really not even talking about practices that have been empirically validated, that there's a strong evidence base for. With generally accepted practices, we look broadly at policing as it is actually done by officers across the country, and we identify the principles and practices that have been distilled from those actual actions by officers across the country, and that's the essence of generally accepted principles and practices in policing.
And is this your methodology and your analysis and stuff, is that what you used in this case to evaluate this case?
It is.
Okay. Just one other thing, we hear about this 20/20 hindsight. Is this 20/20 hindsight looking back to say, well, the officer didn't do this and he should have done this? What is 20/20 hindsight as it relates to
No, looking back at an officer's actions and assessing whether they met whatever standard we're applying is not 20/20 hindsight. That's just review, right? That's just reviewing an officer's actions, reviewing them to again, under whatever different standard we're talking about. Here, I'm applying generally accepted practices, which is a different standard than, for example, what the jury is asked to provide, and a different standard than a supervisor who reviews an officer's actions to determine, for example, whether there were any policy violations. But the act of looking back and assessing an officer's actions against some standard is certainly not running afoul of the prohibition on hindsight. The prohibition on using hindsight, or what's often referred to as the 20/20 vision of hindsight, that refers to taking information that was not available to the reasonable officer at the time, or said slightly differently, taking information that was not reasonably available at the time and acting as if it was available at the time. For example, if an officer is interacting with someone and that person has a rigid, shiny object in their hand and they're making a stabbing motion with it, we assess that and say the officer reasonably believed that that was a knife or some kind of edged weapon. And if later it turns out that that wasn't actually a knife or edged weapon, it was just some kind of harmless plastic toy, we don't go back and say, were the officer's actions appropriate given that this was a harmless plastic toy? That would be applying the 20/20 vision of hindsight. We instead ask, what was the information reasonably available at the time? There was a rigid, shiny object that the subject was making a stabbing motion with, consistent with an edged weapon. And then we assess the officer's actions. We review against those standards as if that was the case, even if we later find out that it wasn't an edged weapon, it was just a plastic toy or something.
Okay, Professor. Now, turning specifically to the facts of this case, okay, did you look at the information that you received surrounding the intersection of sales and estates where Mr. Meade was there with his fellow officers and decided to leave them and head down to the house? Did you look at that particular portion of this case?
Yes, I did.
And based on the facts and circumstances presented to you, did you reach some conclusions with respect to this component of this case?
I did, yes.
And can you explain to us what it is that you saw and what your opinions were on that?
Sure. So my opinion is that that decision to focusing on leaving the other officers and driving down to the end of the road without adequately communicating or coordinating with those other officers as sort of immediately available resources, that was tactically unsound and contrary to generally accepted practices.
And how does and why is it that you came up with that opinion?
So one of the core tactical principles is to ensure that officers have the resources that they need to address a situation. Another one is to ensure that officers are communicating effectively with each other to so that there's no, or at least less room for misperception or miscommunication between officers. When an officer is reacting or responding to a potential, I don't know, let's say suspicious person right now, right? Someone that they believe to be armed, you want other officers, not just in the area generally, but you may you may want those other officers to assist in the immediate tactical approach. It is just safer in that way. In fact, there's pretty good empirical evidence that shows a remarkably reduced injury rate for situations involving multiple officers as opposed to single officers in a number of different contexts. Now, there are some situations where that's just not available. And obviously, as we're applying generally accepted principles or practices, we don't just look for the ideal, we look for in the situation as it actually exists. In this case, there were 3 officers in close proximity who were still equipping themselves, and Deputy Meade left 2 of them behind. That's really leaving some important tactical cards on the table for very little in the way of benefit.
When you say there were 3, you're including Mr. Meade, is that right?
Yes, that's right.
Okay. So what about the communication at that time? Should there have been communication between Mr. Meade and the other 2 as to what's taking place and what's going on?
Yes, absolutely. Officers don't have any kind of like Vulcan mind meld, right? They require normal communication with words or gestures the same way everyone else does. So understanding the purpose of the operation, I want to stop this person, any relevant observations, this person has a gun, this is what they were doing with the gun. And that gives officers not just information about what's happening, it also gives them the chance to coordinate, however briefly, on how they can most safely approach that situation. It doesn't do a whole lot of good to rush up on a situation in an unsafe way if that has a bad outcome. So we certainly don't want to ignore a situation that requires or deserves police attention, but that also means that in order to give it effective police attention, we have to approach in a tactically sound way.
What about factoring in that they're at the intersection and they look down the street and they see, and you've got these facts in the statement from Mr. Meade, but you look down the street and he sees the person, what he claims with a gun, and then turn to walk quickly towards the house. Can you do, and then all of a sudden that's claiming eluding or fleeing. Can you tell us about that as far as how that factors into this analysis?
I'm not aware of any evidence in the case indicating that anyone had identified themselves as the police or had clear visual indications that they were officers. So I don't see how we can get into questions of attempting to evade the attention of police if there's no reason to think that the person is aware that you're the police.
And you're talking about nobody at that point in time yelling or identifying who they were. Is that right?
Sure. I mean, another one of the general principles in policing is certainly that in most situations, we want officers to identify themselves. Often that's not a problem because officers are in uniform or they're in clearly identifiable clothing or the context of the situation, like there's a traffic stop and officers use their overhead emergency lights or something like that. All of those can be good indications. In the absence of that, when we're talking about officers who are less obviously identifiable, who are not in clear uniforms, for example, it becomes much more important for officers to visually or at least verbally identify themselves as the police. That might be just saying police or sheriff's office or something like that. That's important for at least 2 different reasons. One, it reduces potential confusion by the individuals who officers are interacting with. That is, there are at least some number of cases where someone who is not aware that they're interacting with an officer is going to act in ways that we don't want, that they would not act in if they were aware that they were dealing with the officer, right? Just imagine having someone come up on the street and just start yelling "stop" at you, right? That might be a little off-putting, and it's much less alarming and off-putting if you know, oh, they're an officer, right? They're identifying themselves as a police officer. The other reason it's important is because it gives officers a firmer legal basis to take action if the person does not do what they are told to do when the officer has identified themselves. Again, if I'm an officer and I'm just watching someone walk away, that doesn't really mean a whole lot to me. It doesn't have a whole lot of salience. On the other hand, if I'm an officer and I identify myself as an officer and I tell that person to stop and then they walk away, not only have they walked away, but now they've walked away in the context of they know, or they at least should know, that I'm an officer giving them a command, right? So that actually changes the nature of that interaction from someone walking away to someone disobeying a specific police command in a situation where it was clear I am the police.
So in this scenario, did you make a determination that Deputy Meade's actions were tactically unsound? And does that mean then they weren't reasonable?
Yes, that's correct.
Now, the next component is that when driving down to the end of the street to the house, did you evaluate that component in the case?
Yeah, sort of in the same vein that we were just talking about, the decision to drive down to the end of the house and then go up to the fence.
Okay. Then, yeah, so his decision to approach Casey Goodson when he got out of the truck and to approach him, did you evaluate that component?
Yes, I did.
Okay, and can you tell us about that as to your analysis of the defendant's practices here at that component of the incident?
Sure. So again, starting with generally accepted practices, as a tactical matter, as I mentioned, we want to mitigate to the extent possible the dangers of a particular situation or interaction. One of the dangers with someone who is believed to have a firearm is that they may use the firearm, right? So how do we mitigate that particular danger? There are a couple of ways that policing has identified in police tactics that are used for that. One big one is distance, maintaining distance, especially when the individual you're interacting with has a handgun, but you have a weapon with a longer effective range, like a rifle. The Federal Bureau of Investigation does research on officers who are feloniously killed and assaulted in the line of duty. And in the 10-year period from 2010 to 2019, what their data shows is that there's a much higher risk of officers being feloniously killed with a handgun as they're in closer proximity. And that likelihood goes down pretty dramatically as we expand that distance. So about half of all officers killed with a handgun in that period were killed within about 5 feet. 2/3 within about 10 feet of the officer. As soon as we get out beyond that, as we look into the 11 to 20 foot range, it's 10% or so, something like that. And then as we get beyond 20 feet, it's an even smaller percentage, right? About 2% of officers killed between about 21 feet and about 50 feet with a handgun. So if we just sort of think of the visual, right, the risk is much higher with close proximity, and it gets progressively lower as we continue to build distance, and not a ridiculous amount of distance, right? We're not talking about hundreds of feet or even multiple dozens of feet. We're talking about a couple dozen feet, 25 feet, 30 feet, etc. This has led police organizations, including the FBI, to emphasize the need to keep a distance between the officer and an offender, especially a potential armed offender. The FBI published a very explicit guidance for this in a law enforcement bulletin in 2016. The National Police Foundation, working with the Major City Chiefs Association, echoed this in a 2019 report. And in the same vein, but much more recently, the Police Executive Research Forum published something called ICAT, which it stands for Integrating Communications Assessment and Tactics. And they used this equation, distance plus cover equals time, right? The most important variable in police tactics is time, and PERF and ICAT use this concept of distance to explain why it's relevant to time. So first we have this generally accepted practice regarding the actual distance, right? As officers are interacting with individuals who are believed to be armed, you generally want to maintain distance that will help maintain safety by mitigating the potential danger of the situation. Relatedly, but not quite the same, is the potential for using cover or concealment. These are generally accepted tactical practices in policing that relate to the use of obstacles that officers can take advantage of to either prevent an attack from reaching them, that's called cover, or make it somewhat harder for the subject to see them, even if it would not prevent an attack from actually reaching them. That's called concealment. In short, as we're talking about officers interacting with an individual who they believe to be armed, generally accepted principles and practices in policing would tell us that officers should maintain some distance, especially when they have advantage of a weapon that has a longer effective range. And they should take advantage, to the extent possible, of tactical availability of cover or concealment. Taking those generally accepted principles and practices and applying them to this case, that just did not happen.
So I'm going to go back to State's Exhibit number 28.
Rachel? Schroeder, do you have a question?
Yes, I'm sorry, I didn't know it was up. You reviewed, upon looking at this and going to the scene, did Mr. Meade have what you're describing as cover that could have been utilized in this matter?
It's certainly plausible, yes, to have utilized that tree that's just left, just right of center in that image. There's also at least some potential of using the other tree that you can see a little further to the right as something that would provide cover from handgun fire. Even using the fence, which would not provide cover but would provide some degree of concealment, would have been plausible. And that's, of course, to say nothing of positioning the vehicle in a way that could have allowed for tactically appropriate cover or concealment.
Okay. Now, Professor, sometimes officers do have to act quickly to an incident. Is that correct?
Yeah, absolutely.
And in this particular case, relating to this, was there any reason for Officers Meade, you're talking about distance, to approach in the manner that he did?
Yeah, so there are definitely situations where officers have to reply and respond very, very quickly and even aggressively, right? Think of something like an active shooter situation where there is a current extant, like currently existing threat as someone is trying to murder or maybe actively murdering other people. This is not that situation. In an active shooter situation, we have pretty strong reason to believe that other people are actually in danger. It's not speculative. We have a pretty good evidence base to say not just that this could potentially happen, but that it is definitely happening, right? It is a danger, it is a threat, it is harm that is occurring right now. In a situation like this, there are more areas of uncertainty, but uncertainty does not justify bad tactics. Uncertainty does not justify issuing basic safety principles. Maybe the better way to think about this is tactics are about managing risk and reward. They're about cost and benefit. There are lots of tactics that we expect officers to use that will create some danger, right? Running into an active shooter situation puts the officers in danger. That's a cost, and it's not one that we should be light about. However, in the context of an active shooter situation, that cost is worth the potential benefit, because the cost of not doing that is very clear and very, very high. And we go back to that idea of hierarchy of human life, where we preserve the innocent bystanders, officers' lives, and then the subjects or criminal suspects. But without a strong justification, that is, without a clear tactical benefit to doing so, we don't eschew safety. We don't abandon tactically sound principles unless it's justified, unless there is a good contemporary justification for doing that. And just having a situation like this, no, that is not that does not justify abandoning the sort of basic tactical principles of safety, because this is, again, this is not an active shooter situation.
So, was there anything that you saw, I mean, that other than that Casey Goodson was up at his door, that would lead a reasonably objective officer to believe that there was going to be some type of home invasion or anything like that that would maybe fall into what you're talking about, an active shooter or anything along those lines?
No, officers did not have a bunch of information. They did not know if it was not or was Mr. Goodson's house, whether anyone else's was home, whether he was a danger to anyone else. And I want to emphasize that officers did not know that, but that's kind of the normal situation for police officers, is to not know something, right? Here's a very rough analogy. When an officer drives down my street, the officer has no idea whether crimes are being committed behind all of the closed doors on the houses on my street. That does not give them justification to go kick in those doors. In order to justify that tactic, in order to justify doing that more invasive thing, in order to justify potentially raising issues with their own safety and the safety of community members, officers would have to have specific and articulable facts to suggest that there was a crime occurring, that there was an imminent threat that justified that kind of response. So the absence of information is not a good basis to act. The presence of information is a good basis to act, and that's not present here.
So speculating or guessing, is that those are the type of mentality that should not be used in assessing the situation?
I think it's fine for officers to anticipate what might possibly happen, but that's where good tactics come into play. You use good tactics because you anticipate the possibility of things going bad, but you don't abandon good tactics because you anticipate the possibility of things going bad. That's all the more reason to use good tactics. And yes, I agree, officers certainly should not abandon safe tactics just because something might possibly be happening. You abandon good tactics, or a better way to put that is you use situationally appropriate tactics based on the situation that exists, not on the infinite number of situations that might possibly exist.
And how does risk versus reward come into this?
Yeah, maybe the easiest way to think about that is to think about like a pair of old-timey scales, right? What's the tactical risk of doing something, and what's the tactical benefit of doing this thing, right? If we, I'm going to go back to that traffic stop example and say that the officer walks up on the driver's side of that car. Well, the tactical risk of doing that exists, but it's not super heavy, assuming the officer has parked their car in a particular way. So there is some tactical risk with walking up on the driver's side of a car that's parked next to a busy roadway. On the other hand, is there a tactical benefit to doing that? Sure, the officer gets to interact with the driver of the car and actually conduct that traffic stop. On the other hand, if we compare that to the officer climbing over the back and the back and roof of the stopped car, is there any tactical risk to doing so? Yes, the officer could fall off. He could damage somebody's property. It's going to look really weird, which might bring some problems for the agency. So there are those risks as well. Is there any corresponding benefit? Well, we actually have the same benefit. The officer can interact with the person in the car, but in that case, the risks outweigh the benefits. So that's a very rough, go ahead.
In this case, you'd learn through the materials and stuff that Mr. Meade did not seek cover or concealment. Instead, left himself out in the open, basically running forward within 10 to 15 feet of Casey Goodson. Was that sound tactical practice that you saw in that event of this portion of this case?
No, it was not.
And why is that?
In this case, Mr. Meade failed to take advantage of that generally accepted practice of distance that we talked about and cover that we talked about, which increased any danger of exposure to gunfire from Mr. Goodson. And that's a pretty dramatic and substantial increase in risk with really no effective tactical benefit. The officer was Mr. Meade was in no better position to control Mr. Goodson's movements. He was in no better position than he would have been with a rifle to effectively engage him using distance and cover. So there is really no additional tactical benefit, but substantial additional tactical risk. And the risk very clearly outweighs the benefits.
Professor, I want to talk to you about the last portion of your analysis. Well, let's back up. What were your opinions that you came to dealing with the first portion of your analysis?
The first portion, as we were talking about, really focuses on tactics, and as we discussed, in multiple respects, Deputy Meade's tactical approach in this situation was unsound and professionally unreasonable, was not consistent with generally accepted principles or practices in policing.
For the reasons that we've discussed, starting at sales and estates all the way up to this portion of time before the shooting.
Yes.
Now let's move forward to the last portion of when he actually was the shooting occurred. Okay. What did you look at that last portion of your analysis when you talked about the actual shooting when that took place?
Yes.
Okay. And can you explain to us what you looked at that in your analysis, analyzing that portion of the incident?
Sure. So the basic standard that we're applying here that is again, generally accepted principles and practices in policing that governs the use of deadly force. And that principle that officers learn is that officers can use deadly force when the subject presents an imminent threat of death or great bodily harm. Policing defines imminent threat in a fairly specific and well-articulated way. It has 3 different components. The subject has to reasonably appear to have the ability or the physical capacity to cause the type of harm, or the physical capacity here to cause serious bodily injury or death. The subject has to have the opportunity to cause that type of harm. That is, the situation has to be such that someone is vulnerable to being seriously injured or killed. And the subject has to have the apparent intention to cause serious bodily injury or death. So the sort of big picture question there is whether an officer in this position applying generally accepted practices could have concluded that Mr. Goodson presented an imminent threat of death or great bodily harm to the officer or others justifying the shooting. So that's the standard, that's the framework that I'm applying. Looking at the facts, there are multiple, or rather 2, inconsistent versions of the facts. Under Mr. Meade's statement, Mr. Goodson turned and raised the firearm at him, leveling it or pointing it at him at the time he fired. Under the other, sorry, let me just go with that one to keep things consistent. If you accept those facts as true, if you say those are the facts that I believe are in effect, then I think it's actually very clear that there is an imminent threat of serious bodily injury or death in that situation. Applying those facts, Mr. Goodson had the ability with the handgun, the opportunity, pointing it at an officer who was, again, within that roughly 10 to 15 foot range with no cover or concealment, and had the apparent intention to do so because he was turning and lifting the gun towards the officer. So if we adopted that version of the facts, my opinion is that the use of deadly force was reasonable and consistent with generally accepted practices, setting aside everything that we talked about earlier with the tactics, right? Just talking about the use of force. The other version of events, which I understand from Dr. Bauer's analysis in his report.
You may. You may continue.
Thank you, Your Honor. Professor, I guess, let's back up. So you gather all this information. You're not making a determination of what's true or untrue, are you?
No, certainly not. I'm just, as I mentioned earlier in my discussion of methodology, when there is an apparent discrepancy in the evidence, I acknowledge that discrepancy without making any attempt to say that this version is what happened or that version is what happened. That's a decision that is entirely for the jury.
So you're looking at the entire file, you're looking at discrepancies so that you can see what different versions there could be in. Is that right?
Yes.
Okay, so you can continue on. I think there may be a misunderstanding. You were privy to Dr. Bauer's report, right?
I was.
Yeah. Okay, and go ahead. You can go ahead to the second portion of your opinion.
Yeah, so the second portion of that was looking at the facts that suggest that Mr. Goodson had not turned and raised the firearm towards Mr. Meade at the time of the shooting, but was, according to Dr. Bauer's analysis, that Mr. Goodson was instead.
Note your objection, overruled.
Go ahead. It's the basis of your opinion. Go ahead.
I'm sorry?
Go ahead. You can answer.
So Dr. Bauer's report talks about Mr. Goodson not being in a position that is consistent with the description offered by Mr. Meade, that the physical evidence suggests instead that he was inside the house at the level of the kitchen floor and facing away rather than turn towards or lifting the firearm towards Mr. Meade. So taking that set of facts, right, accepting that as true strictly for purposes of my analysis, and to emphasize, without arguing one way or another that that is or is not the correct set of facts, but just accepting it as true for purposes of my analysis, in that situation, there is no imminent threat of death or great bodily harm that would have justified Mr. Meade in shooting.
So in that scenario, if Casey Goodson turned and pointed the gun, okay, you're not saying which way is correct. Is that up to the jury to decide?
It is, yes. It is up to the jury to determine which piece of evidence or which pieces of evidence they find most credible, and to make an assessment about whether that happened or did not happen. I have no opinion and am not involved in that part of the debate.
But as far as use of force goes, if somebody turns and points, you're saying that then it would have been justified.
Yes.
In the other scenario, had he not turned, it would not be justified.
Correct.
All right, we're going to take a, do you have any further questions?
Just one moment.
One question.
And if I could, Your Honor, just would you, we're summing up. So could you please state for the ladies and gentlemen of the jury, your opinions to a reasonable degree of professional certainty that you had in this case after reviewing it?
Sure. By broad overview, the first opinion really relates to tactics in a couple of different respects. Mr. Meade's tactics were unsound, were not in keeping with professional norms, were contrary to generally accepted principles and practices in policing. With regard to the use of force, there is a factual discrepancy. If you believe one set of facts, that is that Mr. Goodson turned and raised the gun towards Mr. Meade, then there was an imminent threat of death or great bodily harm that justified the application of deadly force under generally accepted principles and practices in policing. If you believe the other set of facts, that Mr. Goodson did not turn and raise the gun, but was instead in the house not doing that, then there was not an imminent threat of death or great bodily harm, and thus the application of deadly force was not justified and was contrary to generally accepted principles and practices in policing. It would be unreasonable.
And that's to a reasonable degree of professional certainty.
It is, yes.
Okay.
Doctor,
Thank
Dr. Sullivan, we're going to take a 15-minute break. Ladies and gentlemen, do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. 15 minutes.
All rise.
Put a quick thing on the record.
What's that?
May I proceed, Your Honor, just to put something on the record very quickly?
Very quickly, because she needs a break.
Thank you so much. Your Honor, at approximately 10:06 a.m., Professor Stoughton admitted that he is applying a different standard than what the jury is being asked to apply. Because he's applying a different standard than what this court will absolutely instruct this jury on, we are moving to strike the entire first part of his testimony. Thank you.
Any response?
Using general policing practices, he just testified to it.
All right, 15 minutes.
Here, guys, I'm using these transcripts. I take it you have his report, both of his reports? inquire?
Yeah.
Thank you. Mr. Stoughton, we know each other, correct?
Yes,
And we've spent a lot of time in court together, true?
a few times now, yes.
So you know it's my job as the lawyer to ask you questions, right?
Yes,
You're being paid to be here as a witness today, correct?
I am compensated for my time. Yes, that's right.
And you're a paid witness here to give an opinion to the ladies and gentlemen of the jury, correct?
I'm sorry, say that again.
You just told us that you were being paid to be a witness here, right?
Yes, I'm compensated for my time. The microphone fuzzed out on the next question you asked.
I apologize. And as a paid witness, you are being paid to produce an opinion here today, correct?
No, I'm not paid for my opinion. I'm paid for the time that I put in on the case. I'm certainly paid for the time that I spend writing the report or showing up here to explain the opinions that I reach, but I'm definitely not paid for the opinion.
You would agree with
Is that
me,
what you're asking?
You would agree with me, sir, that your opinion is included in your reports that you have produced here in this case, correct?
Yes.
And you're being paid for your reports, correct?
I'm being paid for time, whether I write a report or not. Like I don't have a separate like report fee or a contract piece that's for the report or anything. But yes, if I write a report, I'm sorry.
Your reports have opinions, true?
Yes.
You're compensated for your reports, correct?
No, I'm compensated for time. Some of that time may be used on the report, but I don't get compensated for the report. I get compensated for time just like anyone working a job where you get paid for the time you do. I don't get paid by the project or by the report or by the opinion. I get paid for time.
And did you put time into this report?
Yes.
Both reports, right?
Yes.
Thank you. Now, if I ask a question that you don't understand, do you promise to tell me that you don't understand so that I may ask a better question?
Sure.
And do you agree to answer my questions in the way that I ask them, rather than trying to answer a different question?
I will do my best to answer the questions that you ask. Yes, absolutely.
I appreciate that, sir. Because if you answer a question I didn't ask you, that will force me to re-ask the original question again, and that would waste everyone's time. Are we on the same page with that?
Sure.
Now, this is an important case, correct?
I mean, I think every case is important, but sure, sure.
So if I were to ask you that you had other obligations and you were too busy to come to Ohio today, how would you answer that?
Well, yes, that's all correct. I found out about the dates of my testimony after already committing to a whole series of obligations this week, which are also important.
Are you saying that the government didn't clear the dates of trial with you prior to you testifying?
We didn't lock down dates of testimony. In fact, I didn't even know that I would be testifying this morning until I think yesterday.
Okay, so when did the government tell you that the trial date for this case was going to commence on April 20th, 2026?
Overruled.
You want me to re-ask that question, sir?
What was the question?
When were you informed that this 3-week trial was going to commence on April 20th, 2026?
I may have had some communication about that at the time of early scheduling, but didn't have any more information until, probably last week about days of testimony.
Okay. And so you filled that 3-week block other obligations then, true?
Yeah, more or less, sure. I wouldn't say that I filled the block, but yeah, I didn't have any idea of when I would be called to testify in that and had never secured dates.
Right, and you testified that your schedule was on the other side of insane, correct?
This week, that is the case, yes.
And so now you get to testify from the comfort of your own home, true?
Yeah, yeah,
Now, before you started your testimony, sir, you swore to tell the truth, right?
yes.
And a witness who doesn't tell the truth should not be believed by this jury, correct?
Sure.
Thank you. Now, I kind of want to start where Mr. Schroyer left off. Do you recall him speaking to you about reviewing Dr. Bauer's report?
Yes.
And that was the basis of your conclusion. You have your report in front of you, sir?
Yes.
You testified to Mr. Schroyer that Dr. Bauer's report was the basis of your conclusion for number 2A, correct?
There were some other bases as well that we did not talk about, but yes, that's the one that we discussed.
You didn't talk about the other bases that led you to that conclusion, correct?
Right.
Okay. Now, you produced 2 reports, true?
Yes.
The first report was produced on June 5th of 2023, correct?
Yeah, that sounds right.
And you would agree with me that on pages 6 through 10 of your first report, you list all the materials that you have reviewed, true?
Yes.
And on your supplemental report, which was provided on August 29th, 2025, you list all of the materials on the same pages 6 through 10 that you have reviewed and coming to your conclusion, correct?
Yes.
Now, I notice on page 10 of your report, it states other materials not specifically listed. Can you tell the ladies and gentlemen of the jury what other materials you reviewed in this coming to your opinion that aren't listed for whatever reason in your reports?
So my goal is always to list out all of the materials that I am provided. I have other materials not specifically listed in the event that I leave one off of that list inadvertently, or sometimes there'll be a very long document, let's say 1,000-page PDF that has a whole bunch of subsidiary documents in it that are distinct. And I may not go through and list. I may not go through and list each one of those. But I don't have anything specifically in mind when I list other materials not specifically listed. That's a catch-all to ensure that in the event that I inadvertently leave one off, I'm not saying that I did not review anything. My goal is certainly to list them all out, though.
So again, specifically relating to this case, there are no materials that which you did not specifically list?
Nothing that I'm aware.
Okay.
I'm sorry, say that last part again.
I'm sorry. As part of your review.
I apologize. I feel like that question was cut in half. What's the question?
I apologize. So specifically related to this case, you're not aware of any materials that you have not reviewed, correct?
Right. Yeah. I think I'm right. I would not be aware of materials that I would not have. Yeah. Right. I think I agree with you. I'm not sure I understand, but I think I agree with you.
You reviewed all the materials listed in your reports, true or false?
Yes.
Thank you.
True.
Do you remember when Mr. Schroyer was talking to you about a police officer identifying himself? And I wrote the quote down, and you stated that you were aware of no evidence in this case that Jason Meade identified himself as a police officer. Do you remember that questioning?
Yes.
Okay, and you agree that that's what you said to Mr. Schroyer on direct examination, true?
Yeah, I think we were talking about verbally identifying as an officer at a particular time in the events, yes.
I think you were talking about police markings also. Do you not recall that part of the conversation?
We talked about uniforms, yes.
Okay,
Overruled.
thank you, Judge. I'd like to talk to you about some of the evidence that you did in fact review that's listed in your reports that clearly identify the police as the police. If I may have the Elmo, Miss Cook. Do you see that, sir?
No, not yet. Yes, now I do.
That's a picture of Jason Meade from December 4th, 2020, correct?
Yeah, so I understand. I'd have to go back and check the date, but that sounds right.
Do you want the time to go back and check the date, sir? Will you take my representation that that was in fact Jason Meade on December 4th, 2020?
No, I'm happy to accept your representation of that.
And on that picture of Jason Meade from December 4th, 2020, he is clearly identifiable as a United States Marshal, correct?
Sure. At the time that we were talking about, he had not yet put on his vest. He was putting on his vest at that point.
So when he pursued Mr. Goodson, he was clearly identifiable as a United States Marshal, correct?
Right, but we were talking about the point at which Mr. Goodson sped up and started walking faster. And at that point, my understanding is he had not put on his vest and started that pursuit yet. So no, he was not.
But then your understanding was he put on his vest, true?
Yes.
And then he pursued Mr. Goodson, correct?
Sure. Then he drove down to the end of the block at that point. Yes.
And at that point, sir, he was in fact easily identifiable as a United States Marshal by his markings, correct?
Sure. Later in the encounter, yes. He was wearing his U.S. Marshal vest.
Now, I want to talk to you about the verbiage that was used. You reviewed Jason's statement in coming to your conclusion, correct?
Yes.
Now, I'm at the point where Jason is in fact pursuing Mr. Goodson while Mr. Goodson is on foot, okay? Okay?
Where are we talking about? Do you mean at the back door inside the fence, or do you mean pursuing as Mr. Goodson is leaving his car and Deputy Meade drives up?
I'm talking about as Mr. Goodson runs toward the house. That's where I'm at, okay?
Overruled. Overruled.
Okay, so I'm sorry, say that again. We're talking about the approach to the house and fence, not the drive up, right?
I'm talking about where Mr. Goodson runs to the house. Are you with me?
Overruled. You can answer the question.
One more time? Third time's a charm. I'll ask it again. I'm talking about
Yes, please.
when Mr. Goodson runs to the house. That's where I'm at, okay?
From the car to the house. That's the section you're talking about.
From the car to the house, sir.
Okay.
Okay? Now, in Jason's statement, as I did so, the suspect pulled open the storm door. I yelled, "U.S. Marshals, it's the police." You would agree with me that at some point during that encounter, he absolutely identified himself as the United States Marshals and the police, correct?
Yeah, but that's not the part you just said we were talking about, right? The portion when he's running from the car to the house, and what you just said, the line that's right after the highlighted portion is he's already at the house. He's at the storm door. So yes, I agree. Later, after he had run to the house, yes, there was the statement, U.S. Marshals, it's the police. That's not any of what we talked about so far.
Nevertheless, he identified himself as the United States Marshals, it's the police, correct?
Yes.
Thank you.
According to his statement, yes, that's right.
Now, you provided a resume to be evaluated for your qualifications as a paid opinion witness, correct?
I don't remember when I provided a resume if that was before my retention or after.
Can you look it up?
Oh, I have no idea when I provided a resume. I wouldn't like separately track that.
Nevertheless, you provided one, correct?
Oh, sure. At some point, like when I turn in a report, I usually provide a copy of a resume that goes with it. Yeah.
Now, your undergraduate degree wasn't in criminal justice, it was in English literature, correct?
That's right.
Now, before you even finished college, you spent a few years as an officer in Florida, true?
Yeah, about 5. Yep.
This was 25 years ago, though, right?
Yeah, starting 25 years ago, ending just about 20 years ago, a little less than 20 years ago.
So, and it was full-time for just less than 5 years, correct?
Yeah, just less than 5 years.
And so your last police work was even before the first iPhone came out in 2007, true?
Yeah, I suppose that's right. My last work as a police officer was.
Things have changed certainly since you've been an officer, correct?
Oh yeah, tremendously. Absolutely.
Now, while you were at that Tallahassee Police Department, how many fatal shootings were you the primary investigator for?
None.
None?
None.
While you were an officer, how many times did you testify in front of a jury about fatal shootings?
Oh God, I have no idea. It wouldn't have been a ton, but I have no idea offhand. I don't know if there were any cases involving fatal shootings testified as a witness.
Thank you. Now, you've never been a patrol supervisor or shift commander, correct?
I served as acting supervisor on a number of occasions as needed on patrol, but I've never held a position as a sergeant or certainly not as a watch commander, no.
You were never on SWAT?
No, I was on well, we didn't have SWAT, right? I was on a special response team.
You said one was like a SWAT team and the other was a special response team. So nevertheless, sir, you've never been on SWAT, correct?
Yeah, that's right.
Now, you testified on direct examination earlier that tactics really aren't special. Do you recall that conversation with Mr. Schroyer?
Yes.
Okay, but SWAT is literally the acronym for Special Weapons and Tactics, correct?
Yes, from the 1970s when we originated that. It was actually originally Special Weapons Attack Tactics, and then it switched to Special Weapons and, yes.
I didn't ask you about the origin or anything like that. I just asked you, SWAT stands for Special Weapons and Tactics, correct?
At most agencies, yes.
And you were never trained as a SWAT officer, correct?
No, I don't have any SWAT certifications.
Now, while you worked at the Tallahassee Police Department, how many times, sir, did the Tallahassee Police Department ask you to be an expert witness for them?
Oh, never as a patrol officer.
Never. Now, you were never certified to be a police officer here in the state of Ohio, were you?
No.
You've never been commissioned or certified to enforce laws here in this state, true?
True.
Now, certainly as a paid witness, you know a lot about Ohio law and what it allows for police officers to do, correct?
Sorry, what do those things have to do with each other?
Sir, I told you my job as the lawyer is to ask the questions, and your job as the witness is to answer the questions. Remember when you agreed to that?
Yeah.
So, let me ask that question. Certainly you know a lot about Ohio law and what it allows police officers to do, correct?
No, that's not my role as an expert.
So, your testimony to this jury is that you don't know what Ohio law affords police officers here in this state?
I believe my testimony to the jury was relatively clear that my role as an expert is to take an officer's actions and to compare them to generally accepted police practices. I don't ask, as I mentioned on direct, whether the officer acted consistently or inconsistently with their own agency's policies. I similarly don't ask whether the officer acted consistently or inconsistently with state law. That's a question for the jury, not for an expert.
So you don't
So
even
I think
know.
the short answer to your question, is no, I'm not applying a legal framework. It would be inappropriate for me to provide a legal framework or offer a legal answer as a police practices expert.
So you're not aware of any laws in the state of Ohio that permit officers to use deadly force?
I'm certainly aware of that, but it's not in my role as an expert, which is why I was confused when you asked earlier. I have some familiarity of Ohio law. I talk about Ohio law with my co-authors in the book, for example, and in other publications where I go through various state laws relating to use of force. But that's totally unrelated to my work as an expert, because my role as an expert is not to apply state law. It's to apply generally accepted practices, which are separate and quite distinct from state law.
So are you saying that generally accepted police practices do not coincide with the law, Professor Stoughton?
What I said was generally accepted principles and practices in policing is a distinct standard from state law.
Do generally accepted police practices follow laws or not?
Do they follow laws?
Correct.
Sure, officers have to act lawfully, but they don't stop at lawful.
And you're not aware of the laws here in the state of Ohio that govern Jason Meade's use of force, correct?
Sure, I have no special, in my role as an expert, I have no opinion as to the laws in Ohio and how they govern the use of force there.
Now, certainly you've reviewed the State versus White case that I have sent you on multiple occasions, correct?
I have.
I sent it to you on February 7th, 2024,
Sure,
September 29th, 2025.
sure.
Nope.
Overruled.
November of 2025,
Yeah, somewhere in November.
April 16th of 2026,
Yeah, okay.
May 1st of 2026.
I have no idea, but sure.
Do you need time to look? I don't want you testifying to things that you have no idea about in front of this jury.
I am happy to accept your representations, but no, once I start going through my emails, my day gets even worse.
Understood. Now, you would agree with me that State versus White is a seminal case here in the state of Ohio, correct?
For what?
Overruled, if he knows.
Sir, you're a law professor, correct?
Yes, I am. A seminal case in what respect? Like a seminal case for a particular proposition, right?
The
Like,
state of Ohio for police use of force. You would agree with that, correct? We're talking about a police use of force here, sir, right? And you would agree
Sure.
with me that that case is in fact seminal, true?
sure.
You can understand why I would want you to know about State versus White, because it allows you to be a better aid to the jury. Would you agree with that?
No, I do not, because I think that it confuses the role of an expert who is providing testimony about whether an officer's actions are consistent or inconsistent with generally accepted practices,
Let's talk
which are the
about,
prevailing norms. I'm sorry, I'm not quite finished. Which are the prevailing norms of policing around the country. And the very specific question of whether an officer's actions are consistent or inconsistent with state law, which is far outside the scope of what I, as an expert, hold an opinion in. And I certainly should not be the one educating the jury on the state of state law. So no, I disagree with that.
okay, well, let's talk about the case of State versus White, sir.
Objection, Your Honor, he's answered the question.
Overruled.
Let's talk about the case State versus White. It actually talks a lot about how police officers are trained here in this state, doesn't it?
Sure, there's at least some discussion of that.
There are 54 times in the opinion, sir, does State versus White mention the word training. You have no reason to disagree with that, do you?
No.
Certainly, you could understand why I would want you to know how police are trained here in this state to be a better aid to the jury in order to say if in fact Jason Meade was consistent with generally accepted police practices, correct?
No, because again, I'm not trying to say that what he did was consistent or inconsistent with state law or what he learned at a state academy. My role as an expert is to assess whether an officer acted consistent with a standard that exists separate and apart from State v. White or the standards you're referring to.
Our officers.
So I don't think it would be helpful for me as an expert to try and inform the jury about the state-specific aspects that you're talking about.
You don't think it would be beneficial to inform the jury of how police officers are trained here in the state of Ohio? Yes or no, sir?
I don't think it would be helpful for me to do that since that's far outside my scope as an expert. I think that might be appropriate for some other witnesses to do, but it is outside of my scope as an expert to do that.
Sir, do you know what yes or no means?
Objection. It's argumentative, Your Honor.
All right, I'm going to sustain that. Let's continue with the questions.
So, generally accepted police practices are different than how police officers are trained here in the state of Ohio?
I would say that generally accepted practices are reflected in how officers are trained. It's certainly reflected in how officers are trained everywhere. But there are aspects of training that may well go beyond generally accepted practices. And there are aspects of generally accepted practices that may be presented in ways other than training, like in the form of policy, for example, or report standards.
So again, police officers are trained based on generally accepted police practices. True?
Not as directly as you're describing, but yes.
Is there a reason why you don't want the members of the jury to know the answer to my question?
I answered your question. Your question has some implicit assumptions that I think hide the actual relationship between generally accepted practices and police training. It's not that I don't want to provide that, it's that I do want to provide that. That's why I'm going beyond the very limited ways that you're asking the questions, which obscure the accuracy of the answer.
Let's talk about generally accepted police practices, sir. You would agree with me that it is a generally accepted police practice that a serious and imminent threat to an officer's safety will permit him to respond with gunfire, correct?
No, you'd need to clarify that a little bit more, right? It's an imminent threat of serious bodily injury or death, not just a serious threat to an officer's safety. But with that wording adjustment, yes, I agree with you.
You would agree with me that it is a generally accepted police practice that a serious and imminent threat of serious bodily harm or death to an officer or to others will permit him to respond with gunfire, correct?
Yes, with that revision, yes.
Now, there's only one standard by which the members of this jury are able to judge a use of force, correct?
Sure, yeah, a criminal jury is only asked to answer one relevant question, yes.
There's one standard by which the members of these juries will be instructed by the judge to evaluate this use of force, correct?
I assume so. I don't want to presume what the judge is going to instruct the jury on, but I would presume so.
I'm not asking you to presume. I actually sent you copies of prior jury instructions that have been provided here in this courtroom, correct?
I think that was on the list, yes.
And in those jury instructions, the one standard by which these folks are to evaluate this use of deadly force is one standard, and that's the Graham versus Connor standard, correct?
I did not look at the jury instructions, so I'm happy to accept your representation of that.
Sir, I sent them to you back in 2024. You didn't have time to look at those jury instructions either?
No, it's not a matter of time. It's that before I do additional review and work additional hours on the case, I consult with the attorneys who retained me and ask whether it's appropriate for me to do that. In the event that it's not going to actually assist my review by helping me apply generally accepted practices or principles of policing to the case, then I would expect to be told, don't do that additional review.
Is that what
So
these
it's not a
prosecutors
lack
told
of.
you?
Stephen, do not speak over him.
I'm gonna object, Your Honor.
Overruled. You can ask a question.
Is that what these prosecutors told you, was don't review the jury instructions that I had sent you?
I don't remember if it was the jury instructions specifically, but there was certainly a general communication where I sent the request to review additional documents to the attorneys, as I've done with all of your emails. And then I believe they kicked it up to an administrator, and yeah, so I understand the decision.
So they told you don't review the jury instructions?
Again, I don't remember if it was the jury instructions explicitly, as opposed to some of the other documents and cases that you sent over and asked me to review. But the short version, and thinking about the prosecutor's office generally and not the two gentlemen there, yes.
Thank you. Now, you're aware that Graham versus Connor is the case from the United States Supreme Court, correct?
It is, yes.
It's the law of the land, true?
It sets the Fourth Amendment civil standard for use of force, yes.
And states can't say, we don't want to follow this standard because it's a mandate from the Supreme Court, correct?
No. It sets a minimum standard of protection. States are free to adopt more restrictive standards with regard to the use of force, but they can't fall below the level of objective reasonableness established in Graham v. Connor.
But they at least have to follow the standard in Graham versus Connor, true?
Actually, no, they don't have to have a law at all. In fact, a handful of states don't have any use of force statute or case law. So there's no requirement. The federal government does not have the authority to require the states to do something. That would violate anti-commandeering.
Sir, Graham versus Connor, every police officer is judged by the Graham versus Connor standard of not being able to use 20/20 hindsight. True or false?
Sure, it's definitely generally accepted in policing that we do not use the 20/20 vision of hindsight, yes.
That's a generally accepted police practice, correct?
Yes, it is.
Now, a federal court has held that your opinion regarding a use of deadly force is inconsistent with Supreme Court opinions, correct?
I don't know if that was quite the quote, but yeah, it was a distinction between generally accepted practices and the Fourth Amendment standard, yes.
I have the case for you, sir, so I'll go ahead and put that up on the Elmo so we can get the exact quote. You testified in the case of Taylor versus Holtmeyer, correct?
Yes.
Okay. And you're aware of that opinion because I've also sent you a copy of that opinion, true?
I have no idea, but I'm happy to accept your representation that you have.
All right, I'm going to show you a page from that opinion. Can you see that?
Not yet. Yes.
To begin with, Stoughton's opinion regarding the use of deadly force is inconsistent with a Supreme Court opinion in Scott versus Harris. Did I read that correctly?
I'm sorry. Okay, can you put it back up?
You see the highlighted part? I'll cover.
I do, but it's moving around. It's moving around a lot.
So it says, but to begin with, Stoughton's opinion regarding the use of deadly force is inconsistent with the Supreme Court opinion in Scott versus Harris. Did I read that correctly?
Yeah, that portion is more or less correct. And later in that paragraph, it talks about the distinction between imminent threat of death or great bodily harm and the general reasonableness standard.
It doesn't, sir.
It does. If you put it back up there, it's the distinction between Scott v. Harris and Tennessee v. Garner. That's the whole bottom half of that paragraph.
So the plaintiff argued in his subsequent, oh, I apologize. It then talks about the plaintiff argued in his subsequent civil suit that the officer's actions constituted deadly force and is warranted only if a suspect poses an immediate threat of serious physical harm to others. Deadly force is necessary to prevent escape, and where feasible, the officer gives the suspect some warning, correct?
Right, and the next sentence is that the Supreme Court in Scott v. Harris changed that approach from Tennessee v. Garner.
And your opinion in that case was inconsistent with the Supreme Court of the United States, correct?
I think it's fair to say that the generally accepted practice I was talking about is not the same as the Fourth Amendment. So yes, I agree.
So you agree that your opinion was inconsistent with the Supreme Court case, correct?
Sure, because they're totally different standards, but yeah, they're different.
Now you would agree with me
Like
that,
that,
may I finish?
please.
You would agree with me that Graham's prohibition for using 20/20 hindsight includes comparative speculation about what an officer could have done differently or whether he should have employed alternate tactics, correct?
That's not in Graham. That's language from White, I believe.
That's correct. So you would agree that generally accepted police practices, 20/20 hindsight excludes comparative speculation about what an officer could have done differently or whether he should have employed different tactics, correct?
No, not exactly correct, right? So what that language that you're reading and referring to means is that just because an officer had an alternative available, that does not mean that the officer's chosen course of action was inappropriate or violated the Fourth Amendment, right? That does not mean the idea that just because there is an alternative, an officer's action is not necessarily unreasonable is definitely correct. But that's very different than the idea that if an officer does something wrong, inevitably, if an officer does something wrong, there are alternatives, right? So I agree with the idea that just because there are alternatives, that does not establish wrongdoing by the officer. But that's not the relevant question. What I'm doing is actually flipping that entirely and saying there was wrongdoing by the officer, and therefore there are other alternatives. But those are totally different things.
Sir, that wasn't my question. My question was, you would agree with me here in this state that Graham's prohibition from using the 20/20 vision of hindsight extends to the testimony of even the most erudite police procedure consultant when it crosses into the prohibited territory of second guessing and armchair reflection. Do you agree with that?
Yeah, that's what I just said. Yes.
This includes comparative speculation couched in backward-looking terms about what an officer could have or might have done differently, and whether he should have employed alternate or lesser means of force or different tactics. You agree with that, true?
Yeah, again, that's entirely consistent with what I just said, right? What the court there is communicating.
Sir, I don't need your
believe.
explanation.
Don't speak over him.
This would go a lot quicker, sir. You're
What
on a
the-
deadline of 12:15, correct?
Yeah, that's the ideal. But that paragraph that you're talking about, I entirely agree that just because there is some backward-looking alternative available, that does not establish officer wrongdoing. That's right. That's inevitably right. As I pointed out on direct, there are a whole spectrum of options, and an officer who chooses one reasonable option will also have other reasonable options. So it can't possibly be the case that the availability of other options will make an officer's actions wrong. However, an officer can act in a way that is wrong. And if an officer acts in a tactically unsound way or uses force when they shouldn't, there's very clearly an alternative. The alternatives don't do the wrong thing. So the approach that you're suggesting, that if there is any possible alternative, that somehow obviates the ability to analyze the incident, just isn't right. It can't be right, because even when an officer does the most egregious thing possible, there is the alternative. The alternative is don't do that thing.
Sir, I asked you if that's what that says. I did not ask for that entire explanation. Your Honor, at this point, I would move to strike the witness's response as non-responsive. He continues to elaborate, knowing that he's got a 12:15 deadline, instead of just answering the questions as yes or no.
You can move on. I'm not going to strike his testimony.
You would agree with me that here in this state, the relevant legal consideration is not what the defendant officer should have known or done, but rather what the reasonable officer placed in his shoes could have believed about the situational need for deadly force in reacting to an imminent threat. You would agree with that, right?
Yeah, absolutely.
Now, during direct examination with Mr. Schroyer, you talked about an increase in danger equals an increase in tactical risk. Do you recall that conversation?
Yes, I recall talking about tactical risk and danger, but I think the way you phrased it is not quite right. But yes, I recall the conversation.
Now, you talked a lot about a topic called officer-created jeopardy on direct examination. You would agree with that, right?
No, I don't think I ever used that phrase.
I'm not saying you use the phrase, sir. I'm talking about the concept that an increase in tactical risk means the officer goes ahead and puts himself in jeopardy, right?
Yeah, so that's not what officer-created jeopardy means. Officer-created jeopardy is a way of referring to unjustified risk-taking. Yeah, sure, we definitely talked about unjustified risk-taking, but that's not the way you just defined it.
And that's what officer-created jeopardy is, right? That's what you just told the ladies and gentlemen of the jury just now.
That it's a way of referring to unjustified risk-taking? Yes.
Do you recall talking about unjustified risk-taking with Mr. Schroyer?
As I just said, yes.
Now, in the Graham versus Connor opinion, you would agree with me that in that opinion, there's no mention of unjustified risk-taking, correct?
No, Graham v. Connor directs us to review the totality of the circumstances, but it does not specify or de-specify anything.
So you won't find unjustified risk-taking in the one standard by which police officers are to be judged for their deadly use of force, true?
One, that's not one standard that officers are used, right? There's several different legal standards. There's administrative and policy standards. Two, yes, officers are evaluated on the basis of their tactics under several different standards. Three, are you going to find the magic phrase unjustified risk-taking in the case Graham v. Connor? No, in the same way that you're not going to find the magic phrase officer-created jeopardy. But that case does direct us to examine the totality of the circumstances of a use of force incident.
Sir, you would agree with me that the jury here today is not going to judge on policies, correct?
I'd hope not.
So we're here, you and I are here, talking about the Supreme Court standard, Graham versus Connor. Can you make a commitment to me to confine your answers to Graham versus Connor? And this will get you out on time.
Yeah, so when you ask the question, is this the one standard that police are analyzed under? The answer is no, right? It's not the one standard. And saying, okay, but can we just pretend it's the one standard? And then when I say it's the one standard, like, that's a really confusing representation of my testimony.
Sir, it's the one
because
standard.
The answer is,
Speak over him.
It's the one standard that juries.
Overruled. I mean, ask the question, but do not speak over him.
Thank you, Judge.
Because Carmen will kill me.
Sir, It's the one standard that juries here in the United States of America judge police uses of deadly force by, correct?
No. 46 states have deadly force statutes. A jury that's convened to assess an officer's actions under state law applies their deadly force statutes. A jury that's convened to analyze the Fourth Amendment propriety of an officer's actions will apply the Fourth Amendment, which is a combination of Graham v. Connor and also the actual deadly force case of Tennessee v. Garner, along with the other line of federal cases that are applied in whatever jurisdiction we're talking about. So when we're talking about juries, no, they don't just apply Graham v. Connor. They also...
Are the state statutes different than Graham versus Connor?
Yes, in many respects they can be, yes. Ohio, from what I understand, adopts Graham v. Connor. It's not important in Ohio because it's the Fourth Amendment. It's important because that's the state law standard that the state adopted. That's where it got it from.
I thought you said you weren't familiar with Ohio law. Now you are?
I'm not familiar with Ohio law in the way that I'm applying it as an expert, but we were talking about State v. White, and that's what that case did.
Correct. So here in the state of Ohio follows Graham versus Connor in State versus White. True or false?
Sure, yes. It incorporates Graham v. Connor into state law in that case, yes.
Now, the phrase that you used, that hindsight is 20/20, you talked about how it's prohibited in front of a jury. I think you stated that if officers don't know what's going on at the time, then you shouldn't take that into consideration. Do you recall that line of questioning by Mr. Schroyer?
I'm not sure what you're referring to there.
You said the phrase hindsight 20/20 means that you can't look at what the officer does not know, correct?
No, that's not quite right. So you don't look at information that was not reasonably available to the officer, right? And the example was the rigid plastic object that an officer reasonably believes is a knife, and unbeknownst to the officer, it turns out to not be a knife. But that's not the same thing as information that the officer is that the officer does not know, right? I'm not sure I understand what you're asking.
Okay, so you just said you don't look at information that's not reasonably known to the officer, right? I wrote it down.
Yeah, right. You look at the situation as it would have reasonably appeared to the officer on the scene, right? Or the information that was reasonably available to the officer. That does include looking at information that's not available, right? Because if it's not available, then like the reality of the plastic toy instead of a knife. So that's still part of the analysis, but you don't imbue that knowledge learned later to the officer.
Don't look at info that's not reasonably available to the officer. I'll say it again for you.
Yeah,
Okay?
yeah, that's right.
So, if an officer doesn't know where that person with the plastic knife was coming from, doesn't know that he just left the Subway store, hindsight prohibits that, correct?
Yes.
And if the officer saw this person with a hood up, covering his ears, and the officer doesn't know that that person had AirPods in, that's prohibited from 20/20 hindsight, correct?
It's certainly prohibited to assume that the officer was aware of that, right? Yes, absolutely. It does not mean that that's not relevant, but it's not relevant for purposes of what the officer was aware of. It certainly can be relevant for assessing the propriety of an officer's observations after the fact, but it's not to dictate the officer's perceptions because the officer couldn't know that information. But it can make reported information more or less likely, sure.
That's not what I asked.
It is. It's literally what you asked. You talked about the use of information that was not reasonably available to the officer at the time, and I explained why that is both not useful and not permitted in one part of the analysis, and why it is useful and permitted in a different piece of the analysis.
And what was the information that I gave you that wasn't reasonably available?
You provided two pieces of information, one of which is where Mr. Goodson was previously at the subway and whether he had earpods in. And my observation with both of those is we should not assume that the officer was aware of either of those pieces of information. But both of those pieces of information can still be relevant to determine what actually happened, which is different than what the officer perceived, and can help us answer the question of whether the officer's perceptions were reasonable.
Again, I'm only asking you what hindsight prohibits. You would agree with me
Right.
that hindsight prohibits whether or not Mr. Goodson had a CCW permit if that information was not reasonably available to Jason Meade. You would agree with that, sir, right?
It would be inappropriate. Hindsight would prohibit assuming that the officer was aware of that. Yes, I agree.
You would agree with me that hindsight would prohibit coming into the equation that Casey Goodson was going into his house if the officer, Jason Meade, did not know that that was his house, correct?
Sure, without the officers, without having any information about the house or who lived at the house, we have neither, yes, we have neither reason to believe that this is or is not his house. Yes.
Now, you're aware that the standard here in the state of Ohio, when judging whether or not a deadly use of force incident was reasonable, that you have to stand in the defendant officer's shoes, experiencing everything that he experienced and acting within the limits of his knowledge as it then existed, correct?
Yeah, I think that's consistent with the standards we were just talking about. Yes.
You would agree with me that facts must be filtered through the lens of the officer's perception at the time of the incident, true?
Sure. Yeah, that's the lens of the reasonable officer on the scene. Yes.
Not the lens of the decedent, Mr. Goodson here, correct?
Yeah, that's right.
Now, I want to talk to you a little bit about, Mr. Schroyer touched on it on direct examination. How much have you already billed the prosecutor's office, sir, for your involvement in this case?
At this point, I think I'm in the area of 90 hours on the case.
90 hours, and that's what, 385?
Yeah.
So I'll do
Three. It's right around the $35,000 since I was retained in 2022.
Yeah, so I think 385 times 90 comes out to $34,650. So you're saying you've billed $34,000, roughly $34,650 to the government?
I mean, roughly that amount in the last, like, almost 4 years. Yeah, something like that.
You would agree that the government works for taxpayers, true?
Sure.
And so the taxpayers are paying you $385 an hour, correct?
Overruled.
I suppose indirectly. I mean, the Franklin County Prosecutor's Office is paying me, and I assume they get all or most of their funding from taxpayers. So I'm definitely not an expert in the funding of the county prosecutor's office.
But certainly you've sent bills to them, true?
Yeah.
And how much is the state paying you per hour to testify right now?
I have a $3.85 an hour rate on days when I'm expected to testify. It's an 8-hour minimum, but there's a contract maximum that I think we're running into.
So you're getting paid today $385 an hour times 8, even though you're not going to be testifying for 8 hours. That true?
That would be my normal invoice practice. As I said, I think we're running into a contract maximum, so it is less than that by some amount, but I haven't done the math yet.
What's that contract maximum, sir?
I believe it's $40,000 over the life of the contract.
So you can't be paid more than $40,000, you're saying?
Yes.
Okay. Now, I want to talk to you about cases that you've been involved in where you're testifying at trial, okay? Are you with me?
Sure.
Perfect.
I think so. Cases that I've testified.
Correct, at trial, okay?
At what?
We're going to talk to you about cases that you've testified while in trial, okay?
Okay. All right.
All right. You have your case list there, sir?
I can.
Let me know when you get a second to pull it up.
Okay. Give me just a second. Okay.
Okay. I want you to go through all of your cases that you have testified in at a trial and tell me where you have testified that the officer did something improperly.
Okay. So just trial, not grand jury. Grand jury.
You got it, sir. Just trial.
Or that's deposition. That's trial. Okay, and I'm sorry, it's testimony at trial that an officer did something improper.
That the use of force was improper.
Oh God, I would have to go back and check each individual case to see what my opinions were on the use of force, but I can certainly give you some broad sense there. So one was Ohio v. Grubb. That was trial testimony.
You testified there.
That's
Sorry, sir. You testified there that the police officers' tactics were outside of generally accepted police practices, correct?
yes.
And the jury didn't agree with you, did they?
Council want to approach?
I
Versus Grubb case, correct?
yes.
And you testified that the police officers, that Officer Grubb, his actions were inconsistent or not consistent with generally accepted police practices, correct?
Yes.
And the jury found The jury found Officer Grubb not guilty, right?
No, my objection, Your Honor. This is a finding by the jury, but no, my objection.
The jury disagreed with you, correct, Professor?
I have no idea if the jury had any opinions as to whether his actions were consistent or inconsistent with generally accepted practices. I think it's probably fair to say that the jury concluded there wasn't proof beyond a reasonable doubt of a crime, which, again, is not the same thing and not a question that I'm answering.
So the jury found Officer Grubb not guilty after you testified that his tactics were improper. True or false?
No, my objection.
Yeah, that's right.
All right, continue on, sir.
Okay. That's deposition, that's deposition. I think the next one is People v. Grayson.
Okay.
Do you want me to have the same discussion about that one or just go on to the next one?
No, sir, let's just go through them.
Okay. That's a deposition. There is a People or Colorado v. Buen, B-U-E-N. That's related to the shooting of Christian Glass. That was trial testimony. Use of force, opinion letter, report. Texas v. Taylor. This case. A case in New York called Nigro, N-I-G-R-O. No, that wasn't a trial. Herndon v. Henderson Police Department. Michigan v. Schurr, S-C-H-U-R-R. That's just grand jury, that's grand jury, that's grand jury. That's deposition, that's deposition. That's grand jury. That's deposition, that's grand jury. That's grand jury. No, that's grand jury, grand jury. Deposition. Minnesota v. Potter. Minnesota v. Chauvin in the George Floyd case. Well, one of the four officers. Ohio v. Coy. It's deposition. Jones v. Pinal, P-I-N-A-L, County. Deposition trial. GIP, G-I-P-P v. Webb. Rhines v. New Jersey, R-H-I-N-E-S.
Sir, are those civil cases?
Some of them, yeah.
Okay. Would you agree with me that GIP and Rhines are civil cases? Or I apologize, GIP was a civil case, correct?
Yeah.
Okay. Okay, I apologize, sir. I just want you to confine that to criminal cases. I'm gonna cross Skip off of this list, okay?
Okay, I mean, a number of those other ones were also civil. Hang on, I can,
I think Blaine was the only one, right? Here, I can show you.
there was a, yeah, sorry, can you show me, can you hold?
But can you see it or not?
No, I'm the other direction.
Okay.
Oh, there we go.
Do you have
Okay, Grayson. Oh, wait,
Here,
it just changed cameras on me.
I'll put one up for you. How about that?
Thank you. This is not the technical difficulty I expected to have.
I don't disagree with that. Those are the criminal cases, correct?
Yeah, so one of the glasses is not, one of those, it's a civil and a criminal. There are two different cases, so one of those is not. Taylor was, Meade was, Nygaard was. Herndon is not. Herndon is civil. Schwer, Potter, Chauvin, Coy. Jones is not. Yeah, Jones is civil. Rhines is civil. Smith is civil.
Okay, hold
And
All right, instead, we're just gonna list them all. I apologize. You can continue.
oh, okay. I have no idea where I was. I'm sorry. Okay.
So sorry, you were
What
at
was
Gip and Rhines.
Gip and Rhines? Okay. Da, 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 da. All right, Gip Rhines. Okay. All right, that one's deposition, no trial. That one's grand jury. That one's deposition, no trial. That one's deposition, no trial. Norton. Oh no, I'm sorry. No, never mind. Not that one. You only wanted cases where I had opinions adverse to officers.
That's correct, sir. That
Okay.
you testified at
Yeah.
trial.
Yeah. That is a very narrow subset of these cases, so I'm having to filter through a lot.
I understand. I think I have two more for you, sir, if that'll speed the process up. I think you testified in Smith.
Yep. Smith, Akilu Smith, v. Charleston County, and Georgia v. Culmer. And I think that's it.
Did you say Comer or Calmer?
Culmer, Calmer.
I apologize. In that case, the Calmer case, you would agree with me when I say that somebody shot and killed a deputy, correct?
Yes.
And you testified that the deputy's tactics who were killed were improper, right?
Yes.
Now, let's list all of the cases where you've testified at trial that the officer used force properly.
Okay. So can I see that list again? Because there are aspects of multiple cases on that list where there was some potentially proper use of force as well as an improper tactic or use of force. So some of the cases are going to fit into more than one category here.
So,
Like there were aspects of the Chauvin case, for example, that I testified are entirely proper and consistent with generally accepted practices. There are just other aspects that are not.
so I want to talk about only cases where you have
Hold on,
testified.
counsel, hold on for a second. Do all the council want to approach?
You've never testified at trial on behalf of a police officer that all of his tactics were in fact, his or her tactics were in fact proper, correct?
Sure, yeah, those cases don't go to trial. So yeah, I have a bunch of grand juries with that as testimony or reports as that as testimony, but in terms of trial, no.
Thank you, sir. Now I want to talk about your words in your report quickly. You would agree with me that you write in your report, the video reflects a northbound vehicle that traveled through the intersection. That's on page 12 of your supplemental report. You would agree with that, correct?
Yes, I think.
Do you need me to put it
Or,
up?
where? Yeah, if you don't mind, I'm trying to figure out where on page 12 we're looking at.
That's fine, Rachel, Ms. Cook, you're fine.
You prevented me from seeing anything.
Let me know when you can see it.
Yep, it's up.
Okay, you agree with me that the video of Carl and Ferris reflects a northbound vehicle that traveled through the intersection, correct?
Yes.
You would agree with me that on page 13 of your report, that it is uncontroverted that Jason Meade absolutely radioed to his team members what was occurring at the intersection of Carl and Ferris, correct?
Yeah, we have Meade stating that, and I think one of the other officers in the record.
Hold on one second, so sorry.
Basis for your objection?
I apologize.
I'll ask him on reading that.
You can continue answering.
We were talking about that Jason Meade radioed to his team what was occurring at Carl and Ferris. You would agree with that, correct?
Yeah, we have Mr. Meade's statement to that effect, and one of the other, I think, SoFast members who said that he described something, although I don't remember there being any location attached to it. I don't remember that part.
You would agree with me when I say that all of the SoFast team ended up back at 3996 Estates Place. You reviewed some of that information, correct?
I did. I think that's right. My only hesitation is I don't know who all was on the SoFast team to have been for all of them to be there, but my understanding is yes, they all ended up there.
Thank you. You would agree with me when I say that based on the information that you reviewed, at least 3 of the officers saw Mr. Goodson running eventually, correct?
Objection. Objection, Your Honor.
Hold on.
Basis?
There's nothing in evidence.
I didn't hear that.
Overruled. You can answer it.
It's all hearsay.
Overruled.
You would agree with me,
Thank you. Please.
You would agree with me, sir, when I say that 3 officers saw Mr. Goodson take off running eventually, correct?
It was not described as running by all 3 of them, but all 3 of them described, I think one described, or maybe 2 of them described him running, and one of them described him walking and picking up his pace a bit.
Thank you. You would agree with me that based on the information that you reviewed, at least 3 people indicated that commands to show hands were given prior to shots being fired, correct?
Yes.
You would agree with me, sir, that there was a gun found near Mr. Goodson, correct?
Yes, so I understand.
You would agree with me that that gun was black, correct?
Yes.
It was a semi-automatic handgun with an extended magazine, correct?
I would have to go back and look for the detail on the magazine, but yes, it was definitely a black semi-automatic.
Would you like to see a picture picture, sir? Will you take my representation that it is an extended magazine?
No, I'm happy to accept your representation.
You would agree with me, sir, that if Mr. Goodson turned and pointed a firearm at Deputy Meade, then Meade's decision to shoot was appropriate, reasonable, and consistent with generally accepted police practices, correct?
I do, yes.
Because at that point, somebody pointing a gun at you is in fact an imminent threat, true?
Yes.
You would agree with me that if a police officer sees a man with a semi-automatic gun and an extended magazine driving his car and pointing that weapon at people, that that officer should pursue that person to investigate further, true?
I don't know about pursue. I think there are some bounds on that. Like, I don't know if that's going to be a good basis for a high-speed pursuit, depending on traffic conditions. But leaving that aside, if we take out pursue and just say the officer should investigate that, yeah, I'm good with that.
If a police officer sees a man pointing a gun at the officer, even for a moment, proper police procedure is to use deadly force to stop that threat, correct?
Ask that question one more time for me, please.
Sorry, it was a poorly worded question. If a police officer sees a man with a gun, pointing that gun at that police officer, even for a split second, proper police procedure is to use deadly force to stop that threat, true?
It often can be. Now, if it's only for a split second and then it's not pointed anymore, the situation has changed. But if we mean like the gun does not have to be pointed for an extended period, yeah, I totally agree.
You would agree that it does not have to be pointed for an extended period of time, correct?
Yes.
And it certainly does not have to be fired in order for the officer to use deadly force, correct?
That's correct.
If someone pointed a semi-automatic handgun with an extended magazine at you, would you be in fear for your life?
Overruled.
It would depend a bit on the circumstances, but I think there's a high likelihood, yes.
Is there a circumstance, sir, in which you can think of somebody pointing a semi-automatic handgun with an extended magazine at you that you wouldn't be afraid?
Sure. If they're 2 miles away, or if I'm in some kind of MRAP or Bearcat or something like that, looking through a protected port, right, then pointing the gun doesn't really mean a whole lot because there's no opportunity. But again, in most circumstances, sure.
What if you were 15 feet away? You'd be in fear for your life, correct?
Yeah, 15 feet with nothing in between me and the gun, yeah.
If someone pointed a gun at you, you would respond as you were trained, correct?
I certainly hope so.
You'd fire your own gun, wouldn't you?
I think there's a pretty good likelihood of it, yes.
More likely than not?
Again, subject to some idiosyncrasies in any given situation, but yes.
Now, sir, you would agree with me that 33 is greater than 5, true?
I mean, just as like numbers, yes, 33 is greater than 5,
And if
yes.
police officers came in who had 33 years of experience as a police officer, you would agree that they're more experienced than you, correct?
Sure, they have more time doing policing, yes.
You would agree that if the lead
And they're-
investigator agreed that it is likely that Jason did the U-turn because he saw a gun, do you have any reason to disagree with the lead investigator for the government?
I'm sorry, that Jason, that Mr. Meade did a U-turn because he saw a gun? Is that what the question was?
Correct. Do you have any evidence to quarrel with that?
Oh, no, I don't even try and get involved in why anyone does anything in terms of subjective motivations. So if someone says I did it for this reason, I note that they said they did it for that reason, but I never quibble with the subjective stuff. I just note what is being said and whether there are discrepancies or not.
So you would agree that if the lead investigator agreed that it's likely Jason did the U-turn because he saw a gun, you have no reason to disagree with that based off of everything that you reviewed, correct?
Sure, I have no idea why anyone did anything, but I think it's fair to say that like the available evidence is that Jason Meade said he did the U-turn because he saw a gun, and yep, that is true. That is a statement.
Thank you, Professor. have no further questions at this time.
Does council want to approach? Not everybody. Stoughton, can you hang with us for a couple questions on redirect?
Sure.
Just
Thank you, Your Honor.
the statements and everything, you're not verifying, saying that the statements, these are accounts that people have made, and it's up to the jury to determine what they said is true or not true, correct?
Can you say that again, please? Sorry.
Reviewed. It's up to the jury to determine whether or not those statements are correct or true made by the individuals. Is that correct?
Yeah, absolutely. I can certainly identify what someone said in their statement, but that's a totally different thing than whether that thing that they said in their statement is true or actually happened or happened in that way. I have no ability to answer that latter question.
Move the microphone so you-
Sounds like you've testified in many states, many cases, and you testified to generally accepted policing practices. Is that correct?
Yes, that's always been the basis of my testimony.
And that includes in Ohio and the Coy case and the Grubb case. You're speaking
Yes.
about generally accepted policing practices. Just real quick,
Yes.
there's a whole list of cases that Ms. Stevens indicated that you had testified at trial. You were talking about grand jury, okay? Have you testified involving police-related shootings in the grand jury?
I have, yes.
Okay, and so she's talking about, whether it's for or against officers and in depositions, is that right?
Yes.
Okay, and in grand jury, if a case doesn't go to trial, that's not going to end up on the left-hand side of her list, is that right?
Yeah, I have no ability to control what cases go to trial or don't. That's and if we're only looking at trials, then we're not looking at most of the cases that I actually work, which might have a report or deposition or grand jury, but don't end in trial.
They don't end in trial, right?
All right, council all want to approach? Oh. I would typically say we're going to take our lunch break, but today we're taking our day break. So if you can be back tomorrow at 8:45 and start at 9, go enjoy the weather. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it's finally submitted to you. Good evening.
All rise.
Please don't have a seat. Do you guys know what exhibits you guys are gonna want? You can have, I have I have my docket that I'm gonna have to go
What
through.
I'm gonna suggest is give us a little time, you've got other things to do right at the moment. Reassemble.
Yeah, that's fine. Good. I've got 27 other cases I gotta deal with.
What time would you like us back?
Whenever you, after lunch, 1:30, 2. I mean, yeah.
Thank you, Your Honor.
Should we deal with the jury instructions at that time?
Give me the yes. I'm sorry, Megan, you're sitting in Rachel's chair. Yeah, Megan is.